to a one-pump course seminar entitled Post-Brexit Changes to the Eligibility Rules a Year On. I'm Ahmed Osman, and I'm a barrister at One Pump Court specializing in housing and community care, along with immigration law, and I'm joined by my colleague in this seminar, Daniel Grütters, who's also a barrister at One Pump Court specializing in housing, community care, and immigration. We've had some small technical difficulties, so that's why we're slightly delayed in starting this webinar, but hopefully we'll be able to get through this plain sailing, although I may have just jinxed us by saying that, but anyway, I've got my fingers crossed. So the UK left the European Union on the 31st of January of 2020, causing a major change in the law of England and Wales. Myself and Daniel will be providing an overview of the changes in the law on eligibility for homelessness assistance under Part 7 of the Housing Act 1996, after the end of the transition period. You may think, well, this was actually some time ago, us leaving the European Union, but there are still elements of that change which are being felt in the law of England and Wales, which lawyers and judges are trying to work their way through. So I still think it has a relevance right now for housing lawyers. In terms of the way we're going to deal with the webinar today, Daniel will go first and he will speak about residents' rights after Brexit, and also give a short overview of the EU settlement scheme. And I will be talking about the impact of those changes on the eligibility of EU nationals and their family members, and also talking to you about the changes to the eligibility framework for EU citizens in light of Brexit. Scott, I think, has helpfully provided the slides for this webinar in the chat. If you do have any questions, please can you put those in the Q&A function, and we will endeavor to answer those questions at the end of the webinar. There will also, I think, be made available a feedback form for those of you to complete at the end of the webinar. So without further ado, I hand over to Daniel.
Thank you, Ahmed, and welcome everybody to our seminar today. Just wanted to start by mentioning I'm coming down with something, so if I seem a little bit off, it's not that I'm not very interested in today's topic. So as Ahmed noted, I'll be talking about two topics today: EEA residency rights and the settlement scheme. Now these slides, they're available, I think, already in the chat. There's a link to a PDF version of the slides, so feel free to go there for your own reference. Now, as set out on this slide, the residency rights of EEA nationals and their family members depend on when they first arrived in the UK. And the cutoff point is effectively 2021 in the EU, or in other words, 11 p.m. on the 31st of December 2020 in the UK. And those who arrive after that point are effectively treated as nationals from any other country. But those who arrive before that point continue to benefit, in effect, from the preferential treatment which EEA nationals and their family members had before Brexit, or more accurately, when the UK was a member state of the EU. Now, it may help to explain very briefly where those preferential treatment rights came from. And essentially, it comes from the European single market, which guaranteed the free movement of goods, capital, services, and workers. And in order to facilitate the free movement of workers, it was agreed that there shouldn't be any impediment to movement across borders. So if someone from Berlin wanted to get a job in Newcastle, they should face as little obstacles as if they wanted to get a job in Munich. And in turn, it was therefore agreed that workers should be able to bring their family members, because if they could not, then that would amount to an obstacle. And so while those rights are based on the EU treaties, they were effectively clarified in what became known as the Citizens' Rights Directive, which was transposed into UK law through the Immigration European Economic Area Regulations 2006 and later 2016. And what those regulations allowed was effectively that if you were an EEA national and a worker, which includes somebody self-employed, or a job seeker or a student, then there wouldn't be any obstacles to your entry into the UK. And the same applied to your family members, and subject to some minor differences, your extended family members. And in practice, this absence of any obstacles was given effect in three ways. First, by removing the need for any leave to enter or remain, at least for the first 3 months, if you met those criteria. So you could show up at Heathrow or Dover or any other port with an EEA identity card or passport, and practically that ought to have been enough to enter the UK. And the second thing is, it enabled, the regulations enabled EEA nationals and their family members to apply for residency cards to evidence that they were using their EU treaty rights. And third, it was possible for people to be granted permanent residency if they had been exercising their treaty rights in any given way for 5 years. So all of that is just to say that sorry about this, I'm having some technical difficulties. Okay, yeah. All of that is just to say that those who arrive after 11 p.m. No longer benefit from those regulations. And you can see here on the slide, if the way in which that's been done is by revoking in effect the EEA regulations. Now you note here at the bottom of the slide that it said that Irish nationals are effectively exempted. And that exemption originates in the Belfast Agreement. It's also known as the Good Friday Agreement, which ended the conflict in Northern Ireland. And in effect, it makes sure that an Irish person is able to enter the UK without any hindrance, as if there were no border, as if there were effectively a single Irish state on the island of Ireland. And that approach means that Irish nationals continue to benefit from preferential treatment regardless of Brexit. So now we get to those EEA nationals and their family members who arrived before 2021. Now, their preferential rights continue until they apply for the EU settlement scheme. Now, I'll get into the details of that scheme a bit later in my presentation. But the point is that those who had preferential rights before Brexit are granted leave to remain when they apply under the scheme. So here you see the mechanism of that approach. In other words, the relevant provisions of the EEA regulations continue to have effect to a relevant person during the grace period. The grace period being 6 months after the end of the transition period. So in other words, that ended on the 1st of July. Now, these next two slides, again, are mostly intended to just be helpful for future reference. I'm not going to read them out in their totality. The key takeaway point for this one and the next slide is that a person may be entitled to leave to remain under the scheme if they had previously had permanent residence. And as I pointed out earlier, the way in which one got permanent residence under the EEA regulations was by exercising their treaty rights for 5 years. So it may well be that someone worked in the UK for 5 years or more in the mid-2000s and then left. And then under these provisions would be entitled to leave to remain if they applied, even though they had left the UK. It's set out here at the bottom of this slide. So these next two slides, again, I'm not going to read them out in totality, but the key takeaway point here is that that the definition of a family member has the same as it had in the EU regulation, and it includes extended family members. And I can touch upon what extended family members means, including the concept of sombrano carers and durable partners during the Q&A, if people find that helpful. But it's quite a niche term, so I haven't. I'm not going to talk about it now unless people have specific questions about it. So here we see the mechanism for the EU settlement scheme. So those who arrived here pre-Brexit continue to have leave to remain. In other words, they get that preferential treatment throughout the grace period. In other words, the first 6 months of 2021. And that leave continues if they make an application under the EU settlement scheme. And Regulation 4.6 makes it clear that if that application is refused for whatever reason, then their leave does still continue up until the period where they're entitled to bring an appeal. And if they bring an appeal during that appeal itself, and that's to make sure that effectively those people who benefited from preferential treatment before Brexit are given every opportunity to ensure that that continues after Brexit, including during any appeals. So, EU settlement scheme then. So, the first thing to point out here is that there was a deadline. As I said earlier, the grace period was the sort of intended to be a hard cutoff point for applications. And any applications made after that deadline, subject to certain specific exceptions, must show reasonable grounds for why the application wasn't made before the deadline. So in other words, this is a category of people in general that is intended to refer to those who came here before 2021, but didn't apply under the EU settlement scheme at that point or by the end of the period. And they then, in order to benefit from the scheme, have to explain why they didn't apply before the deadline. Now, there isn't any reported case law yet on what that means, reasonable grounds. But the examples that the guidance sets out really seems to take the approach that it's, a reason that's outside the control of the applicant. So it sets out children whose parents didn't apply for them, or people who had medical reasons that prevented them from applying. So it appears to be taking quite a strong line, but at the same time, the guidance makes it clear that those examples are not intended to be exclusive, but just examples of the test. Now, I set out there the last bullet point. This is where things get quite complicated. In certain cases, family members of EEA nationals joining an EEA national after the 1st of April 2021 would still have 3 months to apply for leave to remain. Now, the important thing to remember is that we're talking about people who have leave to remain themselves, and it's their family members who are joining them. And there is an open-ended ability for those family members to apply, and they must do so within 3 months of arriving. So if they arrive after the 1st of April. They then have effectively 90 days to make an application under the EU settlement scheme. That application isn't necessarily processed on the same basis as an application would have been before the end of the grace period. But the idea is that the beneficiaries of that rule are the EA nationals who moved to the UK before the end of the transition period. And so that's the relevant focus, and their family members continue to benefit from that, even though they themselves hadn't moved. And that's just to say that if a client comes to you, it doesn't, and they haven't applied for the scheme, it doesn't necessarily mean that they're no longer able to apply, either because there may be a good reason or because they may fall into specific categories of people who are entitled to apply to the scheme beyond the deadline. Again, I'm happy to answer some questions on this later, but I would suggest if you are dealing with a question of eligibility in relation to EA nationals or their family members, you may wish to seek counsel's advice if these sort of issues come up, because there may be a specific category that entitles your client to leave, or effectively means they have leave. So the process then. So unlike most Home Office processes, the EU settlement scheme is at least intended, and I think it's fairly to say generally is fairly straightforward and simple. So it's done online, and if one wants to do it with a paper form, you have to request that, and it's quite a effort to get that. But generally done online. There's an app which is available now on both Androids and iPhones, in which applicants can verify their identity. If that doesn't work, then there's alternative means of doing it. But the idea is that that's an easy, straightforward way in which an applicant can certify who they are. And then they effectively have to provide evidence of residency. In other words, they have to explain from when were they exercising their EU treaty rights. The scheme then has two routes. One is called pre-settled status and the other is settled status. And settled status here refers to indefinite leave to remain. And it is the post-Brexit equivalent of permanent residency. And it's for that reason that it's granted when one has exercised their treaty rights for 5 years, or is a family member of one person who has exercised their treaty rights for 5 years. And pre-settled status is for anyone who falls short of that period. And then once, and so what happens if you haven't completed the 5-year period, you'll be granted pre-settled status, and then you're able, once you reach the 5-year period, to change your status from pre-settled to settled status, which is another category to keep an eye on, because your client may have been granted pre-settled status, but then became entitled to settled status. So that's something to keep an eye on. And Ahmed will be talking about the relevance or the importance of settled versus pre-settled status. The final point that I wanted to mention here, and again, this is subject to there's no yet any reported cases, but I've dealt with it on quite a few occasions, is the approach of the Home Office in general in immigration cases is not one that's consistent with what the withdrawal agreement envisions. So the withdrawal agreement very much requires the UK and the Home Office gives effect to that obligation to help applicants prove their eligibility, and not to take a combative or unhelpful approach to applications under the settlement scheme. And I think that's important because that's different from the general approach the Home Office takes often. So I think I'm gonna leave it there for now, Ahmed, and
I think that's fine. Thank you, Daniel. So I'll take over now. I'll talk about eligibility post Brexit. Now you have some understanding about the context of the immigration changes that took place after the end of the transition period. The first thing to say is that, as Daniel, I think, has alluded to, in relation to new EU arrivals, their situation is akin to somebody from Nigeria, the United States, from India, from all other countries around the world. So basically, in order for them to be eligible, they have to fall within a class of person under Regulation 5 of the Eligibility Regulations in order to qualify for homelessness assistance in England. So that's in relation to those who arrive after the end of the transition period. In relation to those who were here prior to the end of the transition period and who were lawfully resident prior to the end of the transition period and therefore exercising residence rights, the situation becomes somewhat more complicated. The first category of those is those who are granted settled status. So those who have applied for leave to remain under the EU settlement scheme or Appendix EU, as it's called in the immigration rules, they've effectively been granted indefinite leave to remain. So they fall within Class C under Regulation 5.1c of the 2006 Eligibility Regulations, and paragraph 710 of the Homelessness Code of Guidance confirms that. So their case is relatively simple. All you have to do is show they've got settled status, and you have to show they're habitually resident. But I don't think local authorities usually take issue with that point. You may have a very difficult local authority who does, but I think that's unlikely. In respect of pre-settled status, which is the other form of status that a person can be granted if they apply for leave to remain under the EU settlement scheme, the situation becomes more complicated. The first is that you have to actually check what type of pre-settled status they've been granted. So what the underlying basis for the granting of settled status is, because there are two particular exceptions. So just to go back, the general position for those who've been granted pre-settled status is that pre-settled status isn't taken into account when assessing eligibility for homelessness assistance. So what the EU nationals have to show is that they are exercising a qualifying right of residence. So the system is pretty much the same during the grace period for EU nationals. They have to show that they are a worker, self-employed, a student, self-sufficient. They can't be a job seeker. They can't be exercising the initial right to reside for 3 months. They can't be exercising the derivative right to reside, so on and so forth, in order for them to qualify for homelessness assistance, to be eligible for homelessness assistance. But there are two specific opt-outs. The first opt-out is in relation to those who've been granted pre-settled status as a family member of a relevant person from Northern Ireland. They're eligible so long as the relevant person from Northern Ireland was a worker, self-employed person, or an accession state national under Regulation 5.1g of the Eligibility Regulation. I think that's on the next slide, Daniel. Yeah. So that's Class J, and you do have to know, though, in relation to the Welsh Eligibility Regulations, this particular class of person isn't actually that this exception is not contained within the Welsh regulations. So the situation in Wales is actually different to the situation in England. I have no idea why. The second exception is in relation to those who have been granted pre-settled status. Just before I move to the second exception, actually, the reason Daniel, I think, has alluded to it in some extent in this part of the talk, but basically because of the Good Friday Agreement, there is a special situation for individuals who are related to people from Northern Ireland. So that's the reason why they've been given a specific opt-out, which means that even if they've been granted pre-settled status, so long as they've been granted pre-settled status on that basis, that's the reason why they're eligible. Then the second exception is in relation to those who have been granted pre-settled status, who are family members of frontier workers, and they're also considered to be eligible. You might be asking me, well, what's a frontier worker? A frontier worker is basically someone who is resident in one part of the EU, but is working in another part. For the classic example is a lorry driver. So long as that person has been granted pre-settled status as a family member of a frontier worker, they're also considered to be eligible on the Regulation 62K of the 2006 Eligibility Regulations. So as I said, pre-settled status is disregarded for eligibility purposes, other than those two exceptions which I've already cited. And therefore, any EU national has to exercise the right to reside, which is a qualifying right to reside in order to be eligible. And you think, well, this is somewhat of an unfair position, and there has been a litigation on this issue. So there was an argument that disregarding pre-settled status for the purposes of eligibility amounted to unlawful discrimination under Article 18 of the Treaty of the Functioning of the European Union. And this argument was tested in the context of eligibility to access welfare benefits, which had a similar provision mandating disregard of pre-settled status for the purpose of assessing eligibility. And that's the case of Grütters, which was heard in the Court of Appeal. So the facts of Grütters are there were two Romanian nationals who applied for universal credit, which was refused. The basis of that refusal was that they did not have a qualifying right to reside, and that pre-settled status did not make them eligible for welfare benefits. They argued that pre-settled status, disregarding pre-settled status for the purpose of assessing eligibility, amounted to discrimination under Article 18. That's on the next slide, Daniel. You can go to the next slide. Yeah. And then moving on then to the next slide. So the discrimination argument, in effect, was set out in the judgment of Lord Justice Mukum in the case of Grütters, paragraph 16 and 17, as you can see there. And in essence, the argument was that once an EU citizen has been granted a right of residence under the host state's domestic law, in this case, pre-settled status, then the state was obligated to treat that EU citizen the same as a national of that host state. So in this case, the argument is effectively that if a person has been granted pre-settled status as an EU citizen, then they should be eligible to the same benefits on the same terms as a British citizen, which in the case of eligibility for homelessness assistance, which in this case wasn't about, but in this case it would be basically, so long as they can prove habitual residence, they ought to be granted with homelessness assistance, or in this case, welfare benefits. And the appellants relied on a series of cases, which is highlighted in the judgment of Lord Justice Mukum, Martinez Sala, Grzelczyk, Trojani, and Kreefeld to support that argument. The Secretary of State for Work and Pensions argued that the appellants couldn't rely on Article 18 because any discrimination argument could only be made within the confines of Article 24 of the Citizens' Rights Directive. And the difference between Article 18 of the treaty versus Article 24 of the directive is that Article 24 of the directive, that non-discrimination provision can only be relied upon if you are exercising a right of residence that is recognized by that directive. So if you aren't exercising any right of residence, you can't rely on Article 24. There's also a specific derogation in Article 24.2, which says that basically anyone who's a job seeker or who's exercising the initial right of residence for 3 months can't rely on the non-discrimination provision either. So in that case, the Court of Appeal, in the judgment of Lord Justice Mukum, I think that's on the next slide, Daniel. Basically, at paragraph 71, found he preferred the argument of the appellants, and he found that because of the recent case of Kreefeld, which is a Court of Justice of the European Union case, that basically the cases that were being relied upon by the appellant, Martinez Sala, Grzelczyk, and Trojani, those cases are correct, and therefore the appellant's argument on discrimination is correct. They can rely on Article 18, and because they meet because they were granted a right of residence under the state's domestic law, they can rely on that non-discrimination provision. They were effectively being discriminated. It was unlawful discrimination to refuse universal credit. Frutilla was then appealed by the Secretary of State for Work and Pensions to the Supreme Court. That's the next slide, Daniel. And the Supreme Court granted permission in that case, but once permission was granted, while the appeal was ongoing in the Supreme Court, a similar issue arose in the case in Northern Ireland, which was then referred directly to the Court of Justice of the European Union on the exact same issue. And then the Supreme Court decided to stay the case of Frutilla to hear the judgment in the preliminary reference in the case of CJ. And the Grand Chamber gave judgment in CJ on the 15th of July, 2021. Surprisingly, and this is in the next slide, Daniel, the Court of Justice of the European Union decided in the case of CJ that the argument of the Secretary of State for Work and Pensions was actually correct. That Article 18 of the Treaty Functioning of the European Union is inapplicable, that the discrimination provision is inapplicable. And it's in fact the discrimination provision under Article 24 of the directive that applies whenever a person is exercising any form of free movement rights. The next slide, Daniel. And the CJU did, however, find in that case that the refusal of social assistance did engage the rights of CJ under the Charter. For example, the Charter rights of the right to dignity under Article 1, the right to respect for private and family life under Article 7, and the rights of the child under Article 24. And because of that, and because there hadn't been proper assessment of the way in which CJ's rights, the way in which refusal of social assistance in CJ's case wasn't looked at within the provisions of the Charter, the court effectively held that the UK had to assess the situation of CJ and take into with respect to her charter rights and take into account other sources of assistance that were available, because the argument of the Secretary of State for Work and Pension was, well, you can't get welfare benefits, you can't get universal credit, but there are other means by which the UK could fulfill its obligations to her under the Charter. So, for example, assistance on the Children Act, for example. And the Court of Justice found that needs to be properly assessed by the Court of Northern Ireland in relation to CJ's case, which is on the next slide. And then moving on to the next slide. So the matter then returned back to the Supreme Court, who effectively had its hands tied and had to allow the Secretary of State's appeal as a result of the judgment of the CJU and CJ. And in that case, the respondents, the two appellants in the Court of Appeal, tried to introduce arguments about the Charter, but the Supreme Court wasn't having any of it and decided, well, that's an argument that hasn't been raised at all, and the Supreme Court can't be seized of the issue at this late stage. So therefore, the matter was simply allowed, the appeal was simply allowed on that basis. So looking at, therefore, then Frutilla in the case of CJ and the observations to be gathered for housing lawyers, in terms of any arguments in relation to EU law, which obviously now that we are out of the EU, they don't apply anymore in general. The arguments of CJ and Frutilla effectively settle the issue of any litigation in relation to the disregard of pre-settled status for those seeking homelessness assistance. But there's obviously also there was also a suggestion that, well, post-Brexit, reliance could be placed on the withdrawal agreement, because Article 12 of the withdrawal agreement and Article 23 of the withdrawal agreement contain non-discrimination provisions which are in similar terms to Article 18 of the EU Treaty and Article 24 of the Citizens Directive. The issue, of course, and as can be seen from Article 158 of the withdrawal agreement, any interpretation of the withdrawal agreement, the matter can still be referred to the Court of Justice of the European Union for 8 years post the transition period. But the issue with that is that, well, given the judgments in the case of CJ, the CJU, and given the fact that Article 23 of the withdrawal agreement is in materially the same terms as Article 24 of the Citizens' Rights Directive, it's very likely that the Court of Justice of the European Union is going to find, well, it's Article 23 that's applicable, and not Article 12, which is in similar terms to Article 18 of the treaty, and therefore that the disregard for pre-settled status is lawful. And furthermore, in relation to arguments about the Charter, well, the issue with the Charter is that the Charter is no longer part of the domestic law of the UK. I think everybody understood that there was a big brouhaha about the Charter when Brexit was being discussed. Section 5.4 of the European Union Withdrawal Act 2018 makes it absolutely clear that the Charter is no part of domestic law. There may be arguments, because the Charter rights are similar to rights under the European Convention on Human Rights, there may be arguments about the compatibility of the UK's legal regime with the Human Rights Act 1998, but there are particular limitations with the Human Rights Act 1998 that didn't exist in respect to the Charter, so you could actually disapply, as far as I'm aware, legislation relying on the Charter. Of course, you can't do that in relation to the Human Rights Act. So, in relation to pre-settled status, then the person falls on the Class C, and therefore they are eligible pre-settled status, except for those 2 exceptions, as identified. They aren't eligible. All other EU nationals who are exercising a right of residence fall under the old style eligibility rules, so long as they can show that they are a worker, self-employed person, a student, self-sufficient, so they're exercising EU right of residence, that is not being a job seeker and not having derivative to right to reside or exercising the initial right of residence, then they are eligible. So that's my section of the webinar completed.